Legal cases, legal issues, legal matters. You're watching WFTV's Law Talk with anchor Christopher Heath and expert legal analyst, attorney Mark NeJame.
All right, let's talk about some of the current cases, issues, and legal matters that our viewers are talking about. Joining me today is legal analyst attorney Mark NeJame of the NeJame Law Firm, and Albert Yamfa, a partner at NeJame Law in the personal injury division. And okay, so the topic for today is comparative negligence, essentially the idea of not just who's at fault, but kind of how much and what part did each party play, correct?
Yeah, not everybody realizes that, but in Florida we have a very pro-plaintiff aspect of the law. Doesn't mean that we're pro-plaintiff with all of our statutes, but as it relates to this particular area, it can be very favorable to those who get involved in accidents. And what that does basically, comparative negligence apportions responsibility. So even if you get a ticket, it may be that you were primarily responsible, but somebody else is the other person who hit you or you got involved in the accident with, it breaks it down as to percentage. So it might be 90-10, 40-60 or whatever, but then you can still recover on that percentage. So hypothetically, you have a $100,000 claim and it's deemed that you were 40% negligent. Then you can still get $40,000 of that versus the whole amount. But so a lot of times people walk away, they go, well, you know, the officer or the highway patrol trooper said that I was responsible and I got the ticket or whatever. But I didn't do it. It was really the other person's fault. Happens a lot of times, particularly when there's a, you know, they careen off of each other. One's moving into a lane, another's moving into the lane. So you can still make a recovery, and you should definitely talk to your lawyer about that.
And this is one of those things because we have a lot of people here, especially in Central Florida, who moved here from other places. And again, 50 states do it 50 different ways. We're specifically talking about Florida, and in Florida, this is absolutely pertinent if you're involved in any kind of an accident.
That's very true. We are what's called a pure comparative state. Some states have it where if you are found to be 51% at fault for the accident, you're barred from any recovery. And there's still a couple that even say if you're 1% at fault, you're barred from recovery. Even if someone else was 99% at fault for your injuries, you're barred from recovery. So Florida will apportion it. So even if, you know, like Mark said, you're in a situation where you're driving down the road and you get the ticket, you're found to be 90% at fault, technically there's still someone else who's 10% at fault. So you're not barred from recovering just because you were mostly or significantly at fault. And that's important. You can see that in a lot of situations, particularly with what they call open and obvious situations. It's very hard to go through life and not be at least a little bit at fault. Whether you're walking down the road and you trip on a crack on the sidewalk, or slip and fall in some fluid, or you get in a car accident, sure, there's things that you could have done. So it's almost impossible to find 100% negligence from someone else. You know, we all have to watch what we're doing, watch where we're going, conduct ourselves in the most safe way possible. And that's why in Florida, just because you weren't perfect, doesn't mean you're not barred from recovery.
And this is something that, you know, people are going to run into. And you touched on this a little bit, which is, well, I got the ticket, or, well, I was also doing this. And so, you know, they kind of rationalize it in their mind that, you know, maybe, but it's still worth exploring because an incident happened and damages will be occurred.
Without question. And also, you know, the insurance companies are not your friend much of the time, if not most of the time. So they may be sending their adjuster in or their investigator in, and they may want you to think that you are responsible and there's nothing there. Get your own independent representation who's looking out for your best interest and not the insurance company's best interest. So it's exactly what you're saying. You need to know what your rights are, and you need to know what other people's responsibilities are. Because if you're injured and it's partially their fault, if not fully their fault, you have an entitlement, and you need to seek that.
And that is an excellent point. What insurance companies do, one of the two things that they really do, number one is they're going to try and say that any injuries you have are either not related to this particular incident, they're pre-existing, or they're degenerative. But the other thing that the insurance companies love to try and do is apportion as much fault as possible on you and not on their insured. So that's a very good point.
It gets back to something that we've talked about so many times before, which is ask the questions, document everything, and you know what? When in doubt, ask an attorney, get somebody to take an independent look at it because, you know, again, most of us don't have a background in this, find somebody that does.
And at a minimum, come to Law Talk and figure something out. Exactly.
All right, good point. Albert, thank you as always. Mark, thank you as well. If you want to see more of this or any of our other Law Talks, visit our website, wftv.com/legal, or join us each week right here on Facebook. I'm Christopher Heath, and thanks for watching.
WFTV's Law Talk was brought courtesy of the Personal Injury and Accident Division of NeJame Law.